Ready, start. In the judgment of the case Vidyut Metallics Employees Union versus Vidyut Metallics Private Limited, delivered on April 9, 2026, Justice Amit Borkar has held at the Bombay High Court that the word employee in Section 50 of the MRTU and PULP Act 1971 cannot be read as including the union. In the present facts, the petitioner has not shown any permission from the employee. Because of this, the union cannot file recovery in its own name. It has no legal capacity under this section to do so. The order passed by the Industrial Court on April 21, 2023 does not show any mistake in law. It is not perverse. It is within its jurisdiction. There is no reason for court to interfere. Para. Through this petition, the petitioner union has challenged the legality and correctness of the judgment and order of April 21, 2023 passed by the Industrial Court in Miscellaneous Application Recovery ULP3 of 2013. Para. The respondent company at Thane was employing about 1,500 persons, a substantial number of whom were members of the union. A settlement of February 2, 2006 came to be executed between the petitioner and the respondent during conciliation proceedings governing the service conditions of the employees, including wages, allowances, and bonus. Para. Under the clause 11 of the said settlement, the eligible employees were entitled to payment of bonus at least 10 days prior to Diwali. Clause 12 dealt with the payment of ex gratia, whereby it was agreed that such amount would be paid at least 10 days prior to Diwali, and a sum of rupees 320 per employee would be deducted by the respondent and remitted to the petitioner union. Para. It is the case of the petitioner that the respondent failed to pay bonus to the employees as stipulated. Repeated representations made by the petitioner and the workmen did not yield any response. Such conduct, according to the petitioner, constituted an unfair labor practice within the meaning of Item 9 of Schedule 4 of the MRTU and PULP Act 1971. Consequently, the petitioner instituted complaint ULP 425 of 2008 before the Industrial Court at Thane. Para. The Industrial Court passed an interim order on October 23, 2008, directed the respondent to pay 50% of the bonus amount to the employees as interim relief. In compliance with the said order, the respondent disbursed 50% of the bonus to the employees during the pendency of the proceedings. The respondent paid the remaining amount of bonus to the employees and also affected deduction of rupees 320 from the amounts to paid. However, the respondent failed to send the deducted amount to the petitioner union. According to the petitioner, such omission amounted to continuation of unfair labor practice on the part of the respondent. Through the order passed on December 30, 2013, the Industrial Court held that the respondent had engaged in unfair labor practice and directed the respondent to pay to the petitioner the amount of rupees 320 per employee so deducted. Para. Despite this order, the respondent did not comply with the direction to remit the deducted amount to the petitioner union. The petitioner therefore invoked the provisions of Section 50 of the MRTU and PULP Act 1971 and filed recovery proceedings before the Industrial Court for enforcement of the said order. The Industrial Court rejected the recovery proceedings filed by the petitioner through the impugned order of April 21, 2023. This led to filing of the writ petition by the petitioner union.